Great. We're pleased today to have Matt Butler with us. He's the Public Information Officer for the Power Siting Department of the Public Utilities Commission of Ohio. There, he's responsible for Ohio Power Siting Board communication efforts, including public outreach and media relations. And he began work with the PUCO in 2001 and has served in both communication and legislative roles. Prior to joining the PUCO staff, he worked as an aide in the Ohio House of Representatives. Matt earned his bachelor's degree in history from Ohio State. He's an Ohio native and lives in Worthington with his wife and kids. So thank you for being with us, Matt, today to share a little more.
Great. Yeah, thank you for the introduction. I'm going to go ahead and share my screen here. Got a PowerPoint. Can everybody see that?
Yes, we're seeing the presenters vision or
Okay, yeah, I'm going to go ahead and put it into the slideshow mode there.
Right.
Yep. No, I'm having trouble here. There it is. Oh, come on. Huh. If I actually, forgive me here. I'm sorry, guys.
No, it's fine. It's fine.
There we go.
Yep.
That look better?
Looks good.
Okay, great. So yeah, I'm here today to speak with you all about the power siting process, the ways that you all can get involved, the way you can help folks who have questions for you get involved. And we're happy to answer any questions that you have at the end. I know obviously we've been talking about solar here. That's kind of the big thing right now, but we do have a role with other types of projects as well, and I'll get into that here. So the Power Siting Board, in a nutshell, is the state of Ohio agency that reviews plans for the construction of major utility projects in Ohio. And I'll talk a little bit more in a second about what types of projects those are. But what companies are looking for when they come to us is a certificate of environmental compatibility and public need. And essentially that's a permit that says that they're able to, they have the state's permission to construct that project at the location that they've specified in their permit application. The board is a 7-member voting board that represents several state agencies. We have a voting member who is an appointee of the governor who has to be an engineer. And then more recently with Senate Bill 52, which I understand you all learned something about at a recent presentation, we have the involvement now of 2 ad hoc board members for certain projects, only for certain renewable projects. Typically that's new solar projects. And one of those ad hoc members represents the township or townships, and then the same for the county or counties that the project's located in. In addition to that, we have 4 non-voting members who come to us from the legislature. And I'm ahead to the next slide, and you can see that's the actual makeup of the board. So, you can see we've got a pretty wide and diverse set of expertise when we're looking at these projects. The chair of the PUCO chairs the Power Siting Board. And then the directors of those other state agencies that you see there, EPA, Ag, Development, ODNR, and Health, serve on the board. Typically, they'll send a designee to board voting sessions. And then again, the professional engineer and the 4 non-voting members who 2 come from the Senate, DNR, and 2 from the House, the same. So our role beyond just the siting of the facility, if the board issues a certificate, we stick around for the construction, operation, and maintenance of that project for the life of that facility. So we're ensuring, and we're actually doing more now than ever to ensure that each company is following through on the commitments and terms and conditions that they've committed to in their permit or certificate. And we're ensuring that the project benefits the state of Ohio and its citizens, that it promotes the state's economic interests, and that it protects the environment and land use. And I'm going to talk to this to much greater detail in a moment, but public and local government participation are strongly encouraged at any point in our process. So when we talk about major utility facilities and what the board actually has jurisdiction over, we get into three broad categories: generation, transmission, and the natural gas pipelines. Dale was talking earlier about the projects that fit into that 5 to 49.9 range. Our jurisdiction currently begins at 50 megawatts. So any solar project that is capable of generating 50 megawatts more of power, that's a project we're going to have jurisdiction over. For wind, the legislature decided back in about 2007, 2008 to carve that out further down to 5 megawatts. So for wind, our jurisdiction begins at 5 megawatts. And then for fossil fuel powered plants, which recently includes natural gas fired plants, again, just like with solar, jurisdiction begins at 50 megawatts. And we have cited a number of those recently, in addition to solar projects, and those have begun to come online as well. For electric transmission, we're not talking about the distribution lines that run down a suburban or an urban neighborhood, but we're looking at projects that are crossing typically farmland or forested areas that are greater than 100 kilovolts. That's considered transmission level voltage under our rules. And then last but not least, natural gas transmission. This is probably where the smallest amount of our work comes from, but it's still pretty significant. We look at pipelines that are greater than 500 feet in length and 9 inches in diameter, and they've got to have a maximum operating pressure greater than 125 PSI. So for the most part, those projects are one of two types. It's either a line that's supplying natural gas to a power plant that we may cite, and then it's also distribution system pipelines being developed by companies like Dominion and Columbia Natural Gas. It does not include liquids lines. It does not include interstate lines that are crossing over into, Pennsylvania, Kentucky, West Virginia. But it's typically those two types of projects I mentioned earlier. This flow chart here, which is available on our site, opsb.ohio.gov, narrates the board citing process from beginning to end. And I'm not going to go through each step with everybody this morning because that would probably take me half an hour in and of itself. But just to know that this is on our site, if you click on the blue underlined text, it'll actually jump you to the rule or statute in the Ohio Revised or Administrative Code and provide some additional details for you there. But for today's purposes, we're going to break the process down into 6 main areas: pre-application, application and completeness, investigation, hearings, decision, and appeals. And we'll start with pre-application. So our process begins with an optional meeting between the Power Siting Board and the developer, and that's really the developer's chance to seek clarification on board rules, ask any questions that they may have. It's also gives our staff a chance to get a general picture of what the project's going to look like before it actually arrives on our desks. The next thing the company will do is they'll file a pre-application letter and send out a public notice to local landowners that states that they're going to hold a public information meeting, which is in most cases an open house where the developer will provide basic information, including maps. So to give folks an opportunity to begin to learn about the project. We attend those meetings to share information with the public about our process and how they can engage in that. And we often have attendance, especially more recently with wind and solar projects, from local officials who are interested in learning more and may potentially now have a role as ad hoc board members. At least or within 3 months of holding that meeting, they'll file their application with our board. If they don't file their permit application in that 3-month time frame, they'll have to restart the process and hold another public meeting. Once we receive that application, our staff begins a review to essentially ensure that the application contains all the relevant studies, surveys, maps, information that are required under our rules. If the application is deemed incomplete, the project is pulled on hold and it's put back in the developer's court to get that information to us. If it's deemed complete, we send them a letter that says, okay, we're ready to go. We're going to begin our investigation. And that leads us to the next step in the process, which is where our technical staff, which is drawn from primarily the PUCO's staff, but we consult with member agency staff from all the board agencies, including Ag, DNR, EPA. We also coordinate with agencies like ODOT on aviation issues. We coordinate with U.S. Fish and Wildlife Service. And we also coordinate, interestingly, with the Ohio Historic Preservation Office, who has a role in looking at what we call cultural resources. So any archaeological finds that may be present in the project area or historic buildings or residences in the project area. At the conclusion of that investigation, which typically takes about 60 days, the staff will file a report. And that report will be made available. To the right there, you see that's our docketing information system, where all the information in the case is filed from the application on through to the staff report and all the other documents that are filed. And that's publicly available for anyone to go to and see exactly what the staff and the board are looking at. But in that staff report, the board will make recommendations to the board. In that part of that process, we'll review all the public comments and local government input that have been submitted up to that point. And all those, if you see in the docketing information system there, you can see where there's a tab for public comments. If you're on our site and you click on that, you'll actually be able to look at everything that's been submitted from local landowners, but also from township trustees, municipal officials, in some cases, county commissioners may file resolutions or letters in support or expressing their opposition to a project. 2 weeks after that technical staff recommendation is made, we will hold a series of hearings. The first hearing is a public hearing that'll be held in the community as near to the project site as we can locate it. Sometimes that's more of a challenge depending on how rural the area is, but we try to get as close to the area as we can so that it's convenient for members of the public to attend that meeting. The photo you see there is from a hearing not too long ago down in Clinton County for the Yellow Bud Solar Project, if I recall, or Yellowwood Project. Essentially, those public hearings work like a legislative hearing would work. Witnesses sign in when they arrive, and they are called forward by an administrative judge to provide, typically they're given about 5 minutes time to provide their testimony, either in support or in opposition of the project. We often have local officials or leaders of local organizations that may attend and testify at that meeting as well. Shortly after that public hearing, we'll have our second hearing, which is called an evidentiary hearing. Sometimes you might hear referred to as an adjudicatory hearing, but that's a more formal hearing held at our offices in Columbus. And that's where the developer, the OPSB technical staff, and any intervening parties in the case provide expert testimony and face cross-examination from one another. We just had one yesterday in Columbus, again, for this same project that we have the photo of there. That in that particular case, there was a series of delays between the local public hearing, and the adjudicatory or evidentiary hearing. And that sometimes does happen, especially in cases where we're getting a lot of public input, and things may be a little bit more contentious than in a case that just kind of clicks along according to the process. Intervention is something that's available to anyone. Again, it's a more formal step, so often folks are represented by counsel. Local government is given the opportunity to intervene as well. They have automatic right to that as long as they notify us. Usually the county prosecutor will represent counties and townships, but on occasion they'll hire outside counsel to do that. Members of the public, if they join together, so if you have maybe 4 or 5 landowners who team up and hire an attorney, they are required to have an attorney, but an individual landowner can actually intervene on their own behalf. We call that a pro se intervener. And there have been instances where the local landowner themselves comes to that evidentiary hearing and cross-examines the staff, cross-examines members of the or expert witnesses for the applicant as well. We don't typically see that, but it does come up on occasion. Once the hearing record has closed in the case, and again, I want to emphasize too that all that record is transcribed. So during those hearings, everything's written down by a court reporter and gets filed in the case record. Sometimes after those hearings, we will have a period of time where parties may file final legal briefs, summarizing their opinions or their arguments. But then really it goes into the board's hands. They meet once a month, typically on the 3rd Thursday in the afternoon, and they will, in their agenda, which comes out about a week before the meeting, have a slate of cases that they're going to consider that day. And in doing that, they'll bring each case up and then vote to either approve, deny, or approve that project with certain terms or conditions. These are the 8 criteria that the board has to find and determine before it can approve any project, whether it's a electric transmission line, a gas pipeline, or a generation project. That first criteria however, only applies to transmission and pipeline projects, and that is something that's changed since, I believe, 2001, when Ohio made the decision to deregulate generation. And since then, the basis of need requirement hasn't been applied to generation projects like wind, solar, natural gas power plants. But those other 7 conditions 2 through 8 do apply. And you can see that many of those impact the issues that your constituents are concerned about. The environmental impact, how it would impact agricultural viability of land, water conservation, air and water pollution, and most critically, I think, especially with Senate Bill 52, that the facility must satisfy the public interest, convenience, and necessity. But once the board has made its decision, any of those intervening parties has an opportunity to appeal the case. So at the board, we call that rehearing. The board then has a period of time to address that request for rehearing. And if a party is still unsatisfied with the board's decision on rehearing, they can appeal that decision directly to the Supreme Court of Ohio. And believe it or not, that does happen fairly often. I think most recently, the last court decision was in the Icebreaker wind case, which was for wind turbines to be located in the just offshore of Cleveland and Lake Erie. Again, I want to emphasize too that the board's role doesn't end with the siting process. We're around for the monitoring of construction and operation of the facility to ensure that it complies with the certificate that we've awarded. Among other requirements, these are just a few. In each case, the developer will have to establish a complaint resolution process so that anyone who has a concern or a question about a project can reach out to the developer and have themselves heard Ultimately, if a party is unhappy with that resolution process, they can reach out to the board and we'll follow up on that. And we recently have created a compliance division within our power siting department. And that group is specifically going to go out and be on site as much as possible for all the projects across the state, making sure that the projects are complying with the conditions during construction and through operation, but also responding to complaints and following up with what we're calling compliance inquiry reports. And we've already seen a couple of those reports filed in the case dockets, and happy to answer questions about that at the end. Some other ag-related conditions that I thought were important to note were that the applicant would be required to avoid and minimize any damage to field tile drainage system and soils. They're going to have to submit a decommissioning plan to ensure that the facility is able to be decommissioned, removed from the site at the end of its useful life, and that the land be restored to as close to pre-existing condition as possible. And they'll have to post a bond up front that has to be adjusted every 5 years to ensure that those funds are in place. I touched on all these, but I do think it's especially important, again, to emphasize, especially when you're getting questions from again, your constituents, that there are multiple ways to get involved in the process. There's that public informational meeting at the beginning. There's the local public hearing that anyone can testify at. There's that more formal evidentiary hearing that landowners can choose to get involved in if they'd like. And then at any point during the process, folks can file written public comments, and those are filed in the case record and given consideration by both the staff and the board members. Just leave you here with some contact information. I'm available anytime to have a conversation with you. You can reach me by email or phone, whichever's better. But these are other main contact points so that if you have folks who want to reach out to us directly, they can do that as well. Try to make ourselves as available as possible. Always happy to come out if you're interested in doing, follow-up presentation to groups in your area. We're more than happy to oblige that and help out. That is all I have got, but I'm more than happy to answer any questions that you all have.
Okay, thank you, Matt. Questions for Matt?
Matt, I've got a question. Mark Botticher, Hardin County.
Yeah, Mark.
We've got issues in our county with a current solar project. Weeds are growing out of control. They're growing 5-6 feet tall. They're underneath the panels. They're beside the panels. They're along the fence. They have not kept up on mowing them. It's a complete eyesore to the community. The commissioners have contacted them last summer about it. They did see an effort to improve upon it, but this summer, at least when I checked it about 3 weeks ago, it was in terrible condition in both the first phase, it's up in operation, as well as the construction phases that are going on. And I took some pictures too when I was driving around. So do you have a way of dealing with this? That's part of their management of the project, right?
Absolutely. And we have heard those concerns from the community. I know that what we call vegetation management's an ongoing thing. So obviously it's not something they can just do once and say, hey, we fixed it. Those weeds are going to grow right back. There's concerns with noxious weeds and what could happen to neighboring properties as a side effect of that. I do know that we have sent staff up there within the last month to go up to the site and look at that. But we're always happy to go send guys back out into the field and follow up on that. If there's specific areas that you've documented, if you could share those with me, I'd appreciate that. I don't know if you're finding that it's an issue around the entire perimeter of the project, or if there's certain areas where it's more prevalent than others, but any details like that are helpful. But we are working to try and stay on top of that and make sure that they're complying with that requirement.
Well, they did make an effort to mow maybe a half a dozen rows when I looked at it. But other than that, it looked like from the road, it was growing out of control.
Is that in a particular area, or you're seeing it all over the place?
Well, where the current panels are, that are up in operation right now on County Road 110, is
Yeah.
one of the areas. And then just driving south of that area as well, it just seems to be a unmanaged problem. And I don't know if the way they put the panels in, it doesn't look like it would be easy to mow. Because it looks like they've got infrastructure going across, which would make it hard to gain access to get in there and control it. But
Yeah,
I
I
haven't
do-
been on the properties because, I'm not going to go on the properties without permission.
Sure. Yeah, no, I do think it's a challenge for them. And but that doesn't mean that, they're not obligated to follow through on it. And to be honest with you, we're part of the reason we're spinning up that new division is because of all the solar projects and the new challenges that those bring on. So again, if there's any photos that you have that you're able to share, it'd be very helpful. I'll get those to the right people.
And I guess just kind of a follow-up, Mark, if some of those weeds fall under the noxious weed law, that's another independent route to take for weed control. Okay, other questions for Matt?
No, this is Dale, just building upon what Matt said, what Mark's talking about. You're seeing some of the basic challenges right now with regard to that. I've gotten, well, it's interesting, and Matt knows this. I've been involved in 130 case proceedings with the Power Siting Board over the last decade and a half, and we've negotiated a number of stipulations, agreements, and things going forward with regard to management. We control those particular types of things. Matt knows I've worked with him before and sent very competent engineers and folks basically to talk to him and his staff on issues and concerns that we've seen in construction and some projects in the southern part of the state. I've also worked with local county government very recently on some issues and concerns they had with regard to design and construction techniques on some projects that were going to be starting construction within their county and jurisdiction. Many of them were thinking about, we're going to have to go to court and do a number of particular things for enforcement or whatever. And I talked with them and basically said, the Ohio Power Siting Board basically granted the certificate for this particular project. Have you called and notified the Ohio Power Siting Board about your concerns? And they're going, what? And I said, there's this very nice gentleman. His name is Matthew Butler. This is his phone number. You need to call him and let him know your particular concerns so their investigation staff and their folks can be involved in this particular process. I do have to say that they have in a number of cases, a number of folks that have worked through that process and said, that was a lot simpler than what I thought. And I said, I need to explain this. And this could be basically some basic education for a number of local government leaders. If you still have an issue of concern, you don't have to try to go to the local court of common pleas to do a number of particular things. The Ohio Power Siting Board granted this certificate, and they can yank it just as quickly as they've granted it. You call and contact them with your concerns. They investigate, they enforce, and they correct. And they've done that. I think we need to do a better job letting local government leaders know. You give these guys a call, you express your issues, concerns, and you get them basically to enforce the provisions that the certificate was granted under. And I have to also agree with Mark and also with Matt is that we're having a larger number of solar projects now under construction in the state. And we'll see this type of construction over the next decade or so. Those issues and concerns are going to manifest themselves numerous times. And I'm very encouraged and welcome that Matt basically talked today about their new enforcement and compliance division, because that's going to be needed. But making sure this communication between the Power Siting Board, local government, local community stakeholders continues with regard to that. We still need to do that. The process does work. I've had, and Matt can vouch for me, I've had local farmers who had a project done on their property 20 years ago, and were having troubles with the courts and things on current damages when that was upgraded, construction was done. Looking up the certificate, looking up the stipulation, looking up the order that underlies the operation of that particular facility, been able to get people relief and correction today. And so that's the nice focus with regard to the system with the Power Siting Board. And we need to make more people aware of being able to utilize that going forward. Because as Matt said, the Power Siting Board is not going to be going away once a project is permitted. They are there for the entire process of permitting, construction, and operation for decades to come. And we need to get them involved in the process more. But thank you.
And I guess I kind of have a question both for Dale and Matt in a way. So those projects that don't fall under the Ohio Power Siting Board, the solar projects under 50 megawatts, on a lease agreement, could they specify that they want the best management practices for agricultural use, weed management, environmental concerns, referencing that document? You know, wouldn't that be a good way to kind of, I guess, make sure that, you know, those concerns are also addressed in a smaller solar project that doesn't fall under the Ohio Power Siting Board?
Yeah. Well, let me go first. And I say, Matt, you can correct me, but now you know basically the challenge of stuff between 5 and 49.9 megawatts. There's no jurisdiction there. Those particular lease agreements are going to be much more complex to negotiate. You're going to have to take a look at a number of things that the implied protections with Power Siting Board rule, regulation, and process do not apply. Even with that, and this is the issue and concern, if you do have a concern sometime and your lease does say this, what is going to be the regulatory authority, the power siting authority that will enforce corrective matters to be done? That's another issue concern local government is having with a number of these projects between 5 and 49.9, and something that's going to have to be addressed in the legislation.
Dale, do you know if there's any effort at the township or county association level to coordinate and offer up some best practices recommendations?
Yes, I've had meetings with both the CCAO and the Ohio Townships Association and Mid-Ohio Regional Planning very recently to address those particular needs and concerns. Another reason that we need to do this is education outreach to those local government officials. If township trustees and county commissioners are going to be given the responsibility for power siting authority at that particular level, they're going to need to have structure in place. They're going to need to have planning documents, zoning, and other enforcement provisions in place to allow them to be able to do the things at that level that many of the folks at the Power Siting Board and the PUCO are involved with at your particular level, 50 megawatts or above. That's another issue and concern, because the vast majority of townships that are being targeted have nothing at all. That's an issue and concern that we need to address.
All right, any other questions from Matt?
I know it was brought up about the best practices for agricultural production. I think somebody mentioned with the community scale projects. But when I met with 3 individuals from the utility scale project going in at our county, the one that's hasn't been started yet, but was recently approved as of October of 21. I met with the community engagement person. I met with the project manager and the permitting manager of the company. And I mentioned several agricultural issues with them. That was their purpose for meeting with me. We had a discussion of that.
Mhm.
And we were talking about drainage as one of those. And they were mainly concerned with only making repairs to drainage on the mains that affect adjoining fields. They weren't concerned with laterals in the field. And even though I brought up the fact best practices for agricultural production, one of the individuals had mentioned that we're going to put in the facility the development with best practices for solar, because when they put their project in, they're going to do a lot of destruction to the existing tile that's in the field. And there's no way to avoid that with all the posts that they're pounding in the field and the heavy equipment they're going to be running across the field.
Yeah. Mark, this is Dale. If we're talking, are you talking about Fountain Point? Is that the name of the project you're talking about along the Logan-Hardin County line?
I didn't get the exact name of it, but it's going to run between US 68 over by Ridgeway, and it's going to go east to almost State Route 31 over
Okay.
by Mount Victory in the southern part of Hardin County.
Okay, because you named another project started with green or something with regard to that.
Pine Gate.
Pine Gate Renewables is the development company.
Okay. Say Fountain Point is in that county along that particular line. That's the name of the project. I would also say this, and I've seen this so many different times where a company will come in and talk to community leaders and stakeholders such as yourself and say, we're doing these things. And consequently, many of them don't know the process with the Ohio Power Siting Board and what they've had to go through, what they had to agree to with regard to getting their permit with the Power Siting Board. Just recently, and I tell you, this is the pattern. They talk with you in different things. They don't tell you that, you know, they're working with the Power Siting Board. Many folks also don't know that communication with the Power Siting Board about the process and what they're talking about, having Power Siting Board personnel answer a number of questions with regard to their concerns and making them aware of a number of things is absolutely huge. And so I really encourage you to, again, at a different time than this one, give Matt a call, tell him what you've been talking about with this company, voice your concerns so Matt can work with other members of Power Siting Board staff to investigate these particular concerns and discuss it basically with the company on how they're going to be addressed, because as enforcers, that's what they do. Case in point, in a county south of you, just in the last few weeks, a number of local government officials had some issues and concerns with regard to construction of a project and the way it was designed. And they're going, you know, you're the general contractor and you are basically telling us that things are much different than what the company said that they were going to do in this process to protect a number of things. We have some concerns about that. They had a number of discussions with the company, got into several different disputes with them. The county commissioners were looking about going to court and different things and found out that there's very little they could do with regard to the court. They finally called me, and within a phone conference, I said, well, good. This is who you need to talk to at the Power Siting Board. His name is Matthew Butler. You tell him who you are. You tell him basically where you're at, voice your concerns, and let Matt go through the process. What was interesting, this company was going to have its final pre-construction conference with the Power Siting Board within a matter of days of that particular phone call. So I said, do that. Matt, I don't know what the results were, but I do need to say this. 2 of those local government officials called me back and said, wow, you know, what's interesting is I wish I would have had your phone number, knew what was going on, and got a hold of Matt Butler earlier in the process, because it's gotten to be much easier for us to get things done. Mark, I highly encourage you to sit down with Matt, show him those pictures, have his investigation staff and the folks there get involved in the process. And I've been telling that, and it might be an education program for all local officials about how they need to continue to work with the Power Siting Board to advocate correcting their issues and concerns. Matt, I hope I didn't get you into hot water, but do you have anything else to say with regard to that?
No, I agree, Dale. I mean, I think, it does take a partnership between the board and local landowners, officials. When you see things, you're the eyes and the ears right there in the project area all the time. So when you see things or you hear things from people that don't seem that don't seem right, we need to hear about that. And we are out there looking at projects, but we can't be there every day 24/7. So we do appreciate anytime somebody shares concerns, and we'll work to follow up on that.
Yeah.
And we do it every day. We're working on stuff like that every day.
Yeah, that's the power of this particular system. I've had county prosecutors sit down with me and talk, and are going, it was as simple as that, calling this gentleman from the Power Siting Board and getting that staff involved to see these corrective actions being done. And the answer is, that's why you have the Power Siting Board, that part of the Public Utilities Commission, which does these particular things. And you need to continue your relationship with them well beyond when a certificate is granted. The company is not going to tell you that. And I would say this, it might be useful for another program where we talk about this particular issue and do another webinar similar to the last 2 that we've done, to let people know how they continue to work with the Power Siting Board to enforce a number of things. Case in point, I'm going to tell you this. From my discussion with folks and referring people directly to Matt, so Power Siting Board staff can address issues, I've probably averted 5 or 6 different potential disasters having to do with solar, wind, transmission lines, different things, getting them involved, because these folks literally did not know who to talk to address their concerns, and were pleasantly surprised how Power Siting Board staff members and inspectors and different things were able to remedy a situation. So we need to continue that. Mark, I wish you the best of luck. And please work with Matthew to address those concerns on the project. As a matter of fact, I'm going to tell you this. If we're talking about the same project, I was involved in a couple of issues with regard to that, having to do with drainage years ago, and had to advise some folks, here's who you talk to at the Power Siting Board to correct the matter. And they did. Okay, I'm sorry. Go ahead.
Thanks to Dale, obviously, for connecting us to Matt today for his presentation. We thank you. I just want to draw attention to the chat. Christine has posted a couple of options here on the list of agriculture-related attorneys, and a fact sheet also on forage's vegetative cover for utility scale solar. Christine, anything to add on that?
Yeah, I just wanted to mention, Matt, I wasn't sure if you were aware, Eric Romick, myself, James Morris, and a continuing building group of extension professionals have been working to put together some best management practices for sites that may want to consider putting forage crops in as vegetative cover, whether that's for grazing purposes or potentially for harvest.
Mhm.
And we know that a lot of the criteria for making that work happens in the engineering phase. And I think a lot of the people who are involved aren't thinking about it in the engineering phase. They're thinking about it later on what are we going to do now that we have this set up. And, you know, when we have wires running above ground from one set of panels to the other, it makes it hard to drive through. Or if we have hardware sitting in between rows that we have to drive down the row and then back up because we can't get around it to do vegetation management, then those create huge hurdles for us that are barriers to success with whatever type of vegetation management we have. So we understand that doing things like burying lines and reconfiguring sites so that they're more easily accessible does add cost for the developer, but it may save them money down the road with land management. So we are doing research and both literary kinds of reviews, but also on-site, on-farm research to try to come up with best management practices for these installs, and getting developers to think about how they engineer the site with the future in mind. So we don't have great concrete numbers yet to turn over to people and say this is what you need to do, but we have created that fact sheet that I put in the chat to
Mhm.
propose forages as an idea, really comparing them to a turf grass planting versus a pollinator planting, which we've heard a lot of local folks are either making developers commit to a pollinator planting or strongly encouraging it, which also has severe concerns related to weed control as well. So, and also compared to doing nothing, just leaving it fallow or gravel or whatnot. So we put together those thoughts in that fact sheet, and we are continuing to do research. We've recently submitted for a grant from the Department of Energy to expand on that. But you know, obviously, we're a few years away from having that booklet of best management practices ready, but it is something we're really trying to work on to move forward.
Yeah. Christine, this is Dale, building upon what you've just said, and I love you for saying it. If you take a look at now, you know the reason why we as an organization were involved in a number of power siting cases over the last decade and a half, because we saw this issue, we saw this concern, we saw this challenge coming. Please rest assured, and Matt can probably correct me if I'm wrong, but when you take a look at the negotiated stipulations and agreements we advocated for as a party of record or an intervener in all these cases, when you take a look at what we had written into those, which got into the orders, basically, or the certificates or licenses for these particular projects with regard to protection of subsurface field tile, vegetative management plans, pollinator habitat, noxious weed control, all of those particular basic provisions are already in place that they have to obey them. The focus is right now is that, guys, this is what was in your stipulated agreement. This is what's in your order. You are compelled to do those things now and do it. Which means if you have better ways with regard to best management practices and different things to incorporate those things there, you're ready to go. That's the basic things that we've done over the years. That's what we've negotiated with regard to this. Yes, there's a number of projects all across the state. Farm Bureau can't be a police person with regard to it, but we made sure that all of the legal language and things that you need to have to do what you're doing is already there. So if there's an issue or concern or a best management practice or whatever, there's no question that they're able to adapt it, able to use it now, and having the Power Siting Board enforce it now. So I hope I helped you there. Matt,
Yeah.
anything like that?
Yeah, I would just say, Christine, have you been in contact with the Ohio Solar Coalition at all?
If we have, that would be Eric's department. I'm not sure who all Eric has spoke with in our process of getting all these pieces tied together.
Okay.
But Eric is our energy specialist for extension. So he does a lot of the relaying of our team with the other entities that are in energy development, where the other members of our team were either an agronomy focus, or we have our small ruminant specialist that's joined our team as well, to provide that kind of technical support for what we're shooting for rather than the relationships. So I'm
Yeah.
not sure if we have connected with them yet. We have been talking quite a bit with the American Solar Grazing Association because they're big proponents of installing these types of systems.
Mhm.
But that
Yeah,
sounds like that's someone we should be
I'd encourage
contacting.
you to, yeah, it's really, it's the state association, if you will, of the developers who are
Chris,
working across the state.
Matt, this is Dale. I would say this. Yeah, you're talking about UTEC, which is the utility scale solar developers here in Ohio. It's a
Yeah.
member organization of the 14 larger companies. And it's amazing how many community solar developers are now joining that organization. I'll be more than happy to reach out to them because I talk with them on a very regular basis on these particular issues. As a matter of fact, halfway through this conversation, I got a call to talk to their folks because they have a question, which means this: it might be very important, or it might be worthwhile to have them on to do a presentation similar to what Matt has done today. And it's also interesting because they are adopting best management practices. They also see the issues and concerns to address those. Some of their members want to do that extremely well, and others, well, we're a solar project. This is what we're going to do. And I'm going, no, you're not. That's not what you're going to do. It all depends on the discussion of those members. But I can get you, Christy, I can get in touch with USEC. And I would highly encourage us basically to have USEC's new executive director, who's coming on here in the next few days, to come and talk with us, just like Matt has done today, so we understand that and start that in them.
Yeah, that would be excellent. The more we can talk with people and answer their questions, gather more questions to answer, the better off we'll be. So we're
Yeah.
excited we're moving forward with our research, which is really going to be on, if you want to establish forage as vegetative cover, here's what we think you need to do.
Yep.
So hopefully we can sort out all those details, and we could have a paper that we give to them that says, choose your forage, choose your rate, fill in your specs of what your row spacing is. Here's some equipment options that should fit. Here's a essential management plan of timely things that need to happen throughout the year to help them through that, so they're not getting to the end with the site like Mark's describing, where it, kind of these hopes and dreams have fell through the cracks and now it's a mess.
Yeah.
So in response to what Christine's been talking about, I've been discussing two different projects. One that's already in operation and being further developed, which has problems with weeds, and then the new one, which is not yet under construction, but they do have agreements signed with landowners. But I will say, after discussing agricultural issues, we also discussed the positive benefits of bringing solar development into the county as well. So I did ask them about what they perceived the positive benefits were. And one thing, after I showed them pictures of the weeds and the current situation with the project that we currently have, and asked them what they would do to prevent something like this from happening, they did mention that they plan to put a vegetative buffer around the entire project, which will probably consist of some trees and some perennials. And they also brought up pollinator habitat as well. And I mentioned that needs to probably be around inside of the vegetative buffer, because those plants can turn into weeds as well. But that was one of the things that they were going to do. They talked about doing anyway, to, I guess, out of sight, out of mind is what I thought, as far as masking the solar farm. So they don't have to deal with a lot of the public issues.
Yeah. Mark, I'm really glad you said that, because let me tell you this, in that conversation you had with the folks basically from Greenpoint that's doing Fountain Point, Those are already part of their stipulation agreements and certificate order with the Power Siting Board. They haven't told you anything over and above that. They've told you what they have to apply and what is going to be enforced. I would say this, when you sit and talk with them again, you're going to tell them, this is what the Power Siting Board has said in your certificate that you're going to have to do. We can help you with regard to doing that. The question is, are you going to do it? Because I tell you, the people you're talking to, the upper management might know that and will discuss that with you and different things. But I tell you, there is a direct disconnection between them and the contractor they have basically to do the construction. And I've seen that so many different times when they hire that general contractor to do these particular things. Much of that gets ignored. And we need to remind them again, this is what's in your order. This is what you've agreed to do. We'll help you basically to do that particular types of things, but you are going to do it, period. And we need to have more of those particular discussions because that's becoming a growing concern.
Okay.
More
The group did meet with township trustees. I think they also met with the county commissioners, and I don't know about school boards in the area, but they were making their rounds, talking to the different groups in the county.
Yep, they will. That's part of the process. That's part of what they've stipulated or ordered to do. The question is, if they do it correctly and well, you need to tell them that. And if not, you need to get the Power Siting Board involved to enforce what is already agreed upon in their certificate. That's huge.
All right. Hey, thank you, Matt. Thank you, Dale. I'm going to go ahead and stop the recording now. If anyone else has more